Hi, I'm Natalie Remien, and we're here with the Business Law Network. And the great thing about BLN is that it's really just a combination of lawyers who are experts in their fields, and we've all come together to help this organization put together all of their legal needs in one spot. So I hope you enjoy the presentation today. This is going to be on intellectual property, and I'll explain all that I can in 15 minutes, although I do have a lot of slides, so if I'm going too fast, you can always rewind it or whatever, or call me for questions, no problem. And so with that, let's go ahead and get started. The presentation today is really what do manufacturers need to know about intellectual property. And I hope to at least get a couple of good points in there for you today, and if that's all you remember, then that's totally fine. So join us on the first slide here. So what is intellectual property? And a lot of people ask that still. Sophisticated business people still say, what is intellectual property? So intellectual property is really the umbrella under which all sorts of different legal concepts flow, and that is trademarks, copyrights, patents, trade names, just to name a few, trade secrets. And all these different concepts certainly are not the same things. They protect different things, they enforce different things about a business and about their assets. But the big broad heading is intellectual property. So that's why I would say that I'm an intellectual property lawyer. So let's go on to the next one. So we ask why, right? Why are trademarks important specifically to manufacturers and really all businesses? And trademarks are really, we'll go into what they are in a moment, they're really the branding behind your products. And so for a manufacturer who's manufacturing widgets or iPhones or whatever you're manufacturing, food products or whatever it is, all of these different items have brand names and they have logos. And so with those brands and logos are really the lifeblood of your company, really, because when people see those brands, they associate you with those brands, and you pour a lot of marketing dollars behind them. So in order to capitalize and make sure that those assets are safe, you really want to use trademarks as a means of doing that. So today we're really just going to be talking about what are the various terminology, what do the words mean, what's protectable, what isn't, and some basic self-help steps that you can do ahead of time before you contact your lawyer, and also just to have a better conversation with that lawyer about what are your various intellectual property concerns. So let's go into the difference between trademarks and copyrights, because even the most sophisticated businesses that I deal with a lot sometimes misspeak, and they say, I want to copyright this name, or I want to trademark my website or something like that. And I know what they're talking about, but let's get this really, really clear, and that is that trademarks are really associated with brands. They are the names, the logos, or the combinations thereof that really link your product or service with that trademark. Okay, so the golden arches as an example, everyone knows what that is. They know the source of those products anywhere in the world, and pretty much they're consistent anywhere in the world, at least pretty close. So that's really what a trademark does, as opposed to a copyright. Now a copyright, maybe not so prevalent in manufacturing, but what manufacturers do need to know about this is that they all have websites now. So on your website, you probably have some copyrightable information, and that is just proprietary information that you or your company has written and put on your website. Maybe it's about the products, maybe it's about the technical piece behind how you make the products, maybe it's about the process itself. Whatever that is, that you would care if someone took that piece of information verbatim and put it on their website and went into the same business, or made copies of these things and distributed them in association with their business, that would be a problem. You can protect that information with copyright. And we'll go through a little bit more of that in detail in a little while. So this next slide basically just looks at what are some examples of trademarks as we've already defined that. So there's a trademark is really for goods. So a trademark we say is for products. A service mark, you might see SM, and that designation really means the same thing as a trademark, but it's not for goods or service. It's not for goods, it's for services. So both are basically the same animal. It's just that one is for goods and one is for services. Once you obtain a federal trademark registration for your goods or services, you may notice that then there's an R in a circle. As shown on this slide, there is an R in a circle once there's a federal registration. That's the only time in which the R in a circle should be used. And you should not use that R in a circle with generally everything associated with that trademark. You should only use the R in a circle if that trademark has a registration for those particular goods or those particular services. So traditionally we see a trademark, we see the words, the symbols, the combination thereof, as we've discussed earlier. There is such thing as a house mark, and a house mark is sometimes just referred to as sort of a general company name. It's basically a type of trademark, but you know, the name of the company is really oftentimes referred to as a house mark. So you may hear that technology versus a product name or a name of a product line or something really designating the source of that particular good or service. It's really much more of the larger name or the larger umbrella under which all these products fall. So let's take a look at the next slide. The next slide is just showing you some non-traditional trademarks. So what we think of traditionally are names, logos, and things like that, brand names. But these are some off-the-cuff sort of different types of trademarks, but equally powerful. There's even sound marks, and sound marks would be like the NBC chimes. Are certainly a trademark of NBC. Anytime you hear that, you know which network you're on. And so some of these can be very, very powerful as well. Color marks are becoming more and more used in many, many instances. You see the companies sort of capitalizing on color and saying, you know, sort of trying to link that color with their company or link that color with their goods and services. So the next slide is just something that, you know, some examples of what you cannot register as a trademark. Obviously, you can't register anything that resembles or looks or sounds like anyone else's trademark, but what people don't know oftentimes is this different sort of categories. So the immoral, scandalous thing. So if it refers to, you know, some kind of a swear word or something that's, even if it's not exactly the word, this is something that will probably get bounced out of the U.S. Trademark Office. The flag, the coat of arms, the United States, things like that that are owned by states or other municipalities, typically you're going to get bounced. So these are just some things to know as just a matter of background. So what we want to talk about today is that many, many times I hear some of the same things. And sophisticated business people will say, oh, you know, I already have the corporate name, so I'm good. Let's just go ahead and file. And what they don't realize is that that's great, and I'm glad that you were able to obtain that corporate name with the state. But that doesn't mean that the Federal Trademark Office will recognize that you are able to have that name. In fact, somebody other than you may have already registered that name with the Trademark Office. So just to keep in mind that the trademark path is one path and the corporate registration completely another path. And so you shouldn't assume that if you have one, you can have the other or vice versa. The other one is that people go ahead and they register all these domain names. And that's also a really good indication. If you can get all these domain names, then perhaps it's available as a trademark, but perhaps not. So you do need to go through the adequate channels to make sure that you've searched before you file these trademark applications to register them. There's no requirement that you search, but it's always a good idea, because if you don't do the search and then you file something, well, you know, the government, they don't really want to give you your money back. Ever. So, these are some of the common things that people come into contact with. So this next slide is really talking about kind of some self-help tips as far as how do I do this? You know, as I say, I searched it, I typed it into Google, and that's really good because trademark rights are based on use. So if somebody's out there and they have not registered it with the Trademark Office, they still have rights. So Google, MSN, Yahoo, typing it into the first 5 pages of that and really scouring the internet, perfectly fine. But there's also some other places where you should look And if you have the time and you want to do that prior to consulting an attorney, you certainly can. Two of those places are that you can, well, one of the best places to do that is the uspto.gov, which is the U.S. Patent and Trademark Office. On that, you'll be able to search the federal database. What you're searching there is just federal applications and federal registrations. So people that have filed and or become registered. But you will not see the biggest picture there. You'll see most of it, and you'll see some marks that maybe look like yours, maybe don't, and have the same goods and services, or maybe not. But you'll certainly be able to kind of do sort of that self-help step. But understand that that's just federal registrations and applications, and that that's not really conclusive either. There's a state database that you won't have access to that most attorneys do, and that there's also, you know, that common law thing. And also attorneys that practice in this area seem to have sort of a judgment call. I've been doing this for a long time, and I have sort of, yeah, I think just a judgment with respect to this, maybe a gut feeling. I've done a lot of the protection side and a lot of the litigation side, and so as a litigator, I can sort of see back to say, that's risky, or no, that's not so risky because this or that. So an attorney can help you round out the searching once you've done some of these self-help steps. So this slide is really talking about selecting a trademark. If you look at what should it be, right? How do we select a really strong trademark? And we'll go ahead and look at a different slide in a moment that will sort of bring this all together for you. But there's that a trademark has to be distinctive, right? It can't be something that sort of everyone has to use. It has to go well with the branding. Make sure, what does it stand for? Does it say anything about the product? Should it say anything about the product? And also be careful of these foreign equivalents, right? The Chevy Nova, yeah, that means doesn't go in Spanish. That's a problem in Spanish-speaking markets. So you really, really want to, in this global economy, make sure that even if you're not in every country in the world, you kind of want to know that what does your product mean, just in case you should open different markets. So we're looking at how do we select a strong trademark, and this is kind of an interesting slide here because it puts the generic marks on one side, which are totally not protectable as a trademark, and it puts these arbitrary or fanciful names on the other side of the spectrum. So what do we mean by these arbitrary and fanciful things? We mean Xerox, Kodak, Polaroid, things that are names of things that have never been heard of before. These companies made up those terms, they're coined terms, and then they tied them to their products with a lot of marketing dollars, of course. So once they've done that, though, that's really inherently the strongest type of trademark. Things that didn't mean anything before, and all of a sudden they mean your product. So that's the best way. However, it is expensive, of course, to get that tie in the mind of the consumer. So what do most companies do? Most companies should be aiming for something that's suggestive. What does that mean? Well, it doesn't describe, because if it's too descriptive, it's typically not protectable. There are certain exceptions to that I won't get into today. But if it completely describes something about the product or something about the ingredients or something, it's typically not protectable. So what companies really should sort of aim for as this middle ground that it's protectable is suggestive. So a good example of suggestive might be something like Aquafina. Does it say it's water? No, you wouldn't know it's water unless you use some sort of imaginatory leap between the product and what it is. But it does suggest, well, agua in Spanish does mean water, but fina maybe suggests fine or good or some kind of good quality to it. So it does sort of make a suggestion about the product, but it doesn't tell you what it is. So that's actually where you're aiming to make the strongest trademark. This next slide I want to kind of breeze through sort of quickly and just explain a little bit about what trade dress is. You may hear this term. Trade dress is sort of the thing that can protect sort of the visual appearance of a product or its packaging that signifies the source. So the best example I can think of off the top of my head for this is the Coach purse. And ladies, you'll know what I'm talking about. When you see that little hang tag, you know it's a Coach bag from a mile away. So this is one of the things that Coach has done to use it as a source indicator, just like a trademark, but this is actually because of the look and feel of the bag and the look of the hang tag as tied to its product. They call it trade dress. And it is protectable and it is enforceable in the same way that a trademark is, except you don't file these things or register these things in the same way that you would a trademark, because they're sort of a little bit more abstract. You can't register them as clearly or as easily. So the next one are just some examples, some additional examples of trade dress, and you can look at that on that style of slide. So this is important with websites as well, because courts now will consider website as trade dress, subject to certain requirements, of course, but they will consider the look and feel of customizable and customized websites that people have been putting together. So these next slides are a couple of just anticipated questions and answers. What right does a trademark or service mark have? This is basically the right to exclude others from using this thing in commerce. So, and basically what we want to draw from this slide here is that it is, if you have the registration, it is a right that you have, and sort of an assumed validity that you have the right to use this trademark all over the nation. And that's really one of the things we'll talk about when we talk about registration. But a trademark that is registered, you have the prima facie right to use that over all others all over the country. And so that's really what a trademark or service mark does. How long does a trademark last? We get this a lot. The trademarks are based on use, as I said before. It's nice if you have the registration, and from an enforcement standpoint, if you're going to sue somebody else, you really should have that registration. It gives you all kinds of other things, statutory damages, attorney's fees in certain cases, etc. But in general, it lasts as long as you use this trademark in connection with the products and services. So there are certain requirements if it is registered that you have to file renewals and things like that periodically, but as far as when do you lose it, you don't lose it unless you stop using it. So use it or lose it. It's basically right. This next slide is really just saying how do we get trademark rights, and we've been talking about that there is this registration process. It's always a good opportunity to do a search beforehand so you don't waste your money, but the searching is not required. But the trademark applications, as seen here, you can file them on a use basis, or you can tell the trademark office, hey, I intend to use that trademark, but I'm not currently using it. And there are certain advantages to that, certainly. This next one says, why register? And I think I touched on this a moment before. There's constructive notice, so even if other people don't know of your trademark, they should have. So this is a very powerful thing, and also this assumption that you have this nationwide coverage. You can also use it in terms of, well, with the registration, you can do a lot of things. You can license it, you can more easily enforce it through litigation, and you can even use U.S. Customs to help you if there's a counterfeit problem. So I worked with a large multinational retailer. We worked with U.S. Customs all the time. They had pictures of our products, and these things would come in from China, and some of them were our products and some of them were counterfeits, and the U.S. Customs were really, really terrific to help us. And so when we would get these registrations, we would make sure that we're educating them. They would let us know, and this is a real powerful thing, but only if you have that registration. Are there risks in delaying registering or delaying filing for a trademark? There are, certainly, and I'll give you a case example of this one. There was a company that I dealt with that was sort of small, but they had pretty nice nationwide coverage in many, many of the states with their products. And lo and behold, the giant in the industry, shall we say, comes into this market and basically floods the market worldwide. And my client was pretty much in the U.S., although they hoped to go international. But they were pretty much here in the U.S., had pretty good nationwide coverage with their common law rights. Here they are holding these rights, but they didn't file the application. Had they filed the application, this would not have been a case. But it was a big problem because here's the giant in the industry, they file applications, they launch this worldwide launch, and here we are. So I had some leverage to say, well, we can keep you out of Chicago, it's a pretty great market, and we can keep you out of many, many of these areas around the country, so you should probably buy us out. So we had kind of a creative and decent solution for them ultimately, but it was a lot of back and forth. There was a lot of threats going on, and a lot of time and money in drafting some sort of coexistence settlement situation. And ultimately, my client ended up doing sort of a rebrand. And this multinational giant was able to, of course, keep what they did, even though my client was first. So you really want to just file that application because it causes some problems down the road if you don't. This next slide is just sort of here for your review. The principal register is the register that most people hear about. It is the U.S. Trademark Register. If something is too descriptive, it can sometimes be available to get on the supplemental register, but the supplemental register doesn't give you all the rights as the principal register. So if you come in contact with this, you will hear more about it, and I can further explain that. But let's, in the interest of time, maybe move on from here. So this next slide is just talking about international trademark registrations for those of you who are in international business, which is probably many. You will have already come in contact with this. It used to be that you had to file in every single country around the world. That got very, very tough, very expensive as well. Now there are certain communities, certain things that you can do to file one application that covers multiple countries. For example, you can file a community trademark, or we call it a CTM, that would cover all EU countries. Things like this. So it goes into the Madrid Protocol and all these other things. I'll leave that for your review on this slide, but moving forward in the interest of covering sort of the broad brush of many different topics here. This is something that manufacturers and all companies really need to watch. They hire other people to develop certain things for them, of course. Names, logos are no different. So when they hire these people to create stuff for them, the person that created it actually holds the copyright in it. Now, they don't necessarily run out and get it registered, but they typically hold the copyright rights in it unless there's something that assigns it over to your company. And you paid for it, you want it. And most of the time you think, yeah, I paid for it and that's the deal. But not always, it's not always considered a work for hire. It doesn't always fall into these nice, neat categories that are on this slide as well as the next slide. And so if it doesn't fall into these nice, neat categories that the law really deems a work for hire, which would protect you, then you want some piece of paper, and we can draft that for you, saying something that says, hey, if it doesn't quite make it into the work for hire, it is. We paid for it, it's ours. This next slide is just saying, hey, be proactive, don't wait until there's a real problem to contact us. We will still talk to you. And then the last slide is just a little bit about my contact information. So thank you so much for joining us today.